I roll up after a long trip, slam the brakes in my driveway. Smack in the middle of my field, Grandpa's land, every inch I've fought to keep. There's a building, wooden frame, shiny tin roof going up, fresh sign blaring, HOA community office, planted right on the deed, my name on it. I step out, heart hammering. This is real. Gravel crunches. Deirdre Colton, HOA president, khakis razor sharp, clipboard in hand, struts over with a smug grin.
Garth, what do you think? Awesome, right? Our own office at last.
I lock eyes with her, then the building. Take one slow breath and smile. She has zero idea she just gave me the perfect legal kill switch. City bulldozers rolling in to flatten it, all by the book, every penny billed back to her. What would you do right then? Drop Bulldoze below if you'd go nuclear, and share your worst HOA horror story. Let me back up about 30 years, because you need to understand what this land meant before you can understand what burning this woman's scheme down to its footings felt like. My name is Garth Maddox, and I grew up in Calvert County, Maryland, the kind of county where people still shake hands on deals and mean it, where the smell of cut hay in August tells you more about the neighborhood than any Zillow listing ever could. My father, Walt Maddox, bought a 6-acre parcel out on Sycamore Ridge Road back in 1987 for $32,000 cash. He paid it off in 4 years, died with a clear deed. I inherited that land in 2009, along with a beat-up Ford F-250, a shop full of hand tools, and a note on the kitchen table that read, "Don't let anybody push you around, son." For years, the land was mostly pasture, with a gravel drive running up to a modest 2-bedroom house I'd gradually improved. I welded fencing, poured a concrete pad for a workshop, planted a row of white oak saplings along the northern edge. It was mine. Quiet. Simple. The kind of quiet that costs nothing and means everything. The subdivision next door, Whitmore Pines, had been developed in 2004. 42 homes, a neighborhood pool, and a homeowners association with dues, bylaws, and eventually, ambition. For the first decade, they were harmless enough. Their deed-restricted properties started roughly 60 feet east of my fence line. We weren't technically related in any legal sense. My land predated their entire development by decades and was never incorporated into Whitmore Pines. I was not a member. I was not subject to their rules. I was, in every documented and recorded way, separate. Then Deirdre Colton got elected HOA president in the spring of 2021. You've met someone like Deirdre. Maybe not her specifically, but the type. Mid-50s, recently retired from some mid-management county administrator role, where she developed a taste for minor authority and never lost the craving. She drove a pearl-white Cadillac Escalade, wore coordinated pastel outfits on weekdays, and had a laugh that sounded like a screen door hinge, shrill, metallic, and hard to ignore. She had a gift for framing control as generosity. What she was doing wasn't power-grabbing. It was community stewardship. What you saw as harassment was merely neighborhood improvement. Her first move against me was almost laughably small. In June 2021, she sent a certified letter informing me that my workshop, fully on my property mind you, was a visual nuisance visible from Whitmore Pines walking trail, and requested that I install an 8-foot privacy fence at your earliest convenience. There was a Whitmore Pines HOA letterhead. There was an official-sounding resolution number. There was absolutely zero legal authority over my land. I wrote back one sentence. My property is not subject to Whitmore Pines CC and RS. Please confirm you understand this. She did not confirm. She escalated. The next letter accused me of allowing drainage interference from my pasture onto their trail easement, despite the fact that the grading clearly ran the other direction. Then came a noise complaint about my shop compressor. Then a letter claiming my oak saplings were encroaching on a shared visual corridor, a phrase she'd apparently invented for the occasion. The smell of her perfume, something aggressively floral, like a department store counter on Black Friday, started appearing on my porch because she would walk over uninvited to discuss concerns. I started finding her business cards wedged in my mailbox. The woman was methodical, persistent, and absolutely certain that if she applied enough low-grade pressure, I would simply fold up and go along. People like Deirdre Colton have won that way before. They pick someone they think won't fight back, and they grind. Slowly, politely, relentlessly. She had picked the wrong pasture. By September 2021, Deirdre had graduated from letter writing to what I can only describe as bureaucratic sorcery. She went down to the county planning office and filed a request for a boundary determination review. Not a survey, not a legal challenge, just enough paperwork to create a cloud of ambiguity on record. She told the planning clerk that there was a long-standing dispute over the eastern boundary of my property, which was news to me and to every document ever filed about the land. I found out because the county mailed me a notice, standard procedure, and I drove down to the planning office on a Wednesday morning with a manila folder full of documents, so organized it made the clerk blink twice. Original deed from 1987, survey from 1994, another survey I'd commissioned in 2017 when I poured the concrete shop pad. The legal description on every single one of them placed my eastern boundary exactly where I said it was, 62 feet west of the Whitmore Pines subdivision markers. The clerk looked at my folder, looked at Deirdre's complaint, looked back at my folder. "Sir," she said quietly, "I don't think this review is going to go anywhere." I told her I understood and thanked her for her time. Here's what Deirdre didn't count on. Bureaucratic machinery runs both ways. While I was at the county planning office, I asked a simple question. I said, "While I'm here, are there any active permits or applications tied to my parcel number?" The clerk typed it in, frowned, typed something else. "There's a zoning variance application filed last month," she said, "for a small accessory structure on this parcel. Did you file this?" I had not filed anything. I leaned on that counter and read the application carefully. Someone, and it didn't take long to figure out who, had filed a variance application using a legal description that smeared the boundary between my property and the HOA's common area parcel. The application was for a community services building, approximately 400 square feet. The applicant of record was the Whitmore Pines HOA. The signature line showed a notarized signature from Deirdre Colton on my land. I'm a pretty calm man by nature. My shop runs clean, my tools are organized, my language is mostly rated PG. But standing in that county office, reading a permit application for a building on my property, filed without my knowledge, without my consent, using a deliberately fudged boundary description, I felt something shift deep in my chest. Not rage exactly, more like the quiet, cold click of a decision locking into place. I made 2 phone calls that afternoon. The first was to a real estate attorney named Prescott Dalby, 3rd-generation local, the kind of lawyer who wears suspenders unironically and has a mounted bass on his office wall. The second call was to a licensed land surveyor named Hoke Bridwell, who I'd used before and who had a reputation for being precise to a point of personal pride. I told Hoke I needed fresh stakes in the ground by end of week and a certified survey report in my hand within 10 business days. "You got a problem with a neighbor?" Hoke asked. "Working on it," I said. What I didn't do, and this matters, was make a scene. I didn't call Deirdre. I didn't fire off an angry email. I didn't show up at the Whitmore Pines HOA meeting waving my deed. Every instinct in a normal person's body says go confront the person doing this to you. That instinct, while completely understandable, is almost always the wrong move. When someone is operating on the thin edge of legality, the best thing you can do is let them keep operating, while you quietly build the file that will bury them later. I went home, poured a second coffee, and sat in the shop for an hour sharpening chisels. The rhythm of it helped me think. The smell of metal and machine oil has always done that for me. The variance application was still pending. It hadn't been approved. In Maryland, a zoning variance requires a public notice period, a planning board hearing, and, critically, notification of adjacent property owners. I was the adjacent property owner. I had received no notification. That was procedural violation number 1. Prescott confirmed it the next morning. "Garth, if they built anything on that parcel description before this variance cleared, and especially without your notification, we've got them on multiple fronts. Especially if they built anything." 2 weeks later, I came home from a hardware run to find a freshly framed structure sitting in the corner of my pasture. 4 walls, a metal roof going up, a little sign that read, "Whitmore Pines Community Services Office, zip-tied to the frame. They'd gone ahead and built it. God help them. They had actually gone ahead and built it. I stood at the edge of my gravel drive for a long moment, looking at that frame. The lumber was fresh. You could smell the pine sap and cut wood from 20 feet away, clean and sharp against the late October air. Someone had poured a small concrete footing already cured, which meant they'd been planning this for weeks, maybe months. The whole thing was maybe 12 by 30 feet, not enormous, but sitting on my land with the certainty of someone who had never once considered the possibility of being wrong. Deirdre pulled up in her Escalade about 4 minutes later. She had a hard hat on, a white hard hat naturally, and she was smiling the way people smile when they're very proud of themselves. "Garth, what do you think? We've been working so hard on this. It's going to be such a nice addition to the community." I looked at her. I looked at the building. I pulled out my phone and started filming, panning slowly from the structure to the property stakes Hoke had driven 2 weeks earlier, clearly visible in the turf. Then I filmed Deirdre standing in front of it. "You want to be in the video?" I asked. Her smile wobbled slightly. "What video?" "Just documenting," I said. "Beautiful morning for it." I let her talk. This is another thing I can't stress enough. Let people who've done something wrong talk. Deirdre stood there and explained the whole plan, how the HOA board had voted on it, how she'd filed all the necessary paperwork, how the building would serve as a community hub for meetings and package deliveries. She said it would benefit everyone in the area. She said she hoped I would see it as a bridge between our communities. I nodded and smiled and kept the camera running. She said probably 300 words I would later quote back to her in a cease and desist letter. That afternoon I sat down with Prescott and we went through the situation methodically. Here is what we had documented at that point and why each piece mattered. The 2017 certified survey showed my eastern boundary at a specific GPS coordinate, confirmed by 2 independent markers Hoke had now restaked and photographed. The HOA's variance application used the boundary description that shifted my line approximately 18 feet westward, a discrepancy that conveniently placed their new building just inside what they were claiming was their property. But it was not their property, it was mine. This was not a surveying disagreement. This was a falsified boundary description on a government permit application. That's called fraud. Prescott said it in exactly that word, in a flat voice, without drama. The variance application also remained unapproved. The planning board hearing was scheduled for December, meaning the structure had been built before approval. That's a zoning violation. Prescott wrote that down too. I had not been notified of the variance hearing as an adjacent landowner, despite it being a legal requirement under Maryland code. That was a procedural violation that would, on its own, be sufficient to invalidate the variance, even if everything else had been clean. And then there was the simplest thing of all, the most fundamental, almost embarrassingly basic fact underlying everything. They had built a permanent structure on land they did not own, without the owner's permission. That is trespass. That is encroachment. In Maryland, it also opens the door to a civil action for adverse possession prevention, meaning I could go to court and get a judgment confirming my ownership and ordering the structure removed at their cost. Prescott drafted a formal cease and desist and a notice of encroachment that week. We served it on Deirdre personally and sent certified copies to every member of the Whitmore Pines HOA board. Deirdre's response came 4 days later, via her own attorney, a guy named Thaddeus Winspear out of Annapolis, who had a website photo of himself standing in front of bookshelves that were clearly decorative. His letter essentially argued that the HOA had been operating under a reasonable belief that the boundary was as described in their variance application, and suggested that I was being adversarial in pursuing the matter rather than seeking a community-minded resolution. Prescott read it, set it down, and chuckled. "They want you to donate the land." "I figured," I said. "They're going to figure out fairly quickly that that's not going to happen." "Let them figure it out slowly," I said. "We're in no hurry." November arrived cold and fast in Calvert County, the kind of cold that comes off the Patuxent River and gets into your jacket collar no matter how you button it up, smelling of wet leaves and far-off wood smoke. I was doing morning chores one Friday when I noticed something new. A small laminated sign had been zip-tied to my fence post, the one at the corner of my pasture closest to the Whitmore Pines walking trail. It read, "Whitmore Pines Community Annex, grand opening December 15th, All Whitmore residents welcome. They were planning a grand opening of a building on my land that had been built illegally, that was currently the subject of an active cease and desist letter. I pulled the sign off my fence, put it in a Ziploc bag as evidence, and called Prescott. Prescott made a call to the county planning department to flag the active encroachment for the upcoming variance hearing. He requested that the hearing include our survey evidence and objection filing. The planning clerk noted the objection and confirmed it would be part of the record. Meanwhile, I started making quiet inquiries. One of the things I'd wondered since the beginning was how Deirdre had managed to file a variance application using an incorrect boundary description without anyone at the county catching it. The answer, when it came, was not surprising, but was definitely useful. A neighbor of mine, a retired utility worker named Cresswell Dobbs, who lived a quarter-mile down Sycamore Ridge and missed absolutely nothing, mentioned over a fence-line conversation that Deirdre Colton had apparently served on the County Planning Advisory Committee as a volunteer for several years. Not as an official, not in a role with any real authority, but as the kind of familiar face that gets waved through and whose paperwork gets processed without the usual scrutiny. That's not corruption in the criminal sense, but it's the greased wheel version of influence, and it explained why an application with an obviously doctored boundary description had moved through the queue without a red flag. Deirdre had cultivated just enough familiarity to make people assume her paperwork was correct. I passed this along to Prescott. He noted it. He also began looking into the HOA's finances, specifically how the construction had been funded. HOA boards are required under Maryland law to maintain financial records and make them available to members. Deirdre, of course, had made sure those records were as inconvenient as possible to access. No digital portal, request-only format, 48-hour response window. But the records were available. One of the Whitmore Pines homeowners, a quiet, meticulous man named Rupert Calloway, who'd been frustrated with the HOA board's opacity for years, had already requested the financials several months earlier and been stonewalled. When he heard about the encroachment situation, Rupert came to see me. He had a manila envelope. Inside was a partial financial statement he'd managed to obtain through a formal records request that had taken 3 follow-up letters. It showed a $47,000 capital expenditure in August 2021, labeled only as Community Infrastructure Improvement. There was no line item detail, no contractor invoice listed, no board resolution authorizing the specific expenditure. $47,000 for a 12 by 30 framed building with a metal roof, built on land the HOA didn't own. I stood in my kitchen looking at that number and thought about Walt Maddox paying $32,000 in cash for 6 whole acres and 4 years of pride. $47,000 to build a box on someone else's pasture. Rupert sat at my kitchen table with his coffee and said what we were both thinking. Where did the rest of that money go? Because a 12 by 30 frame structure does not cost $47,000. A contractor who knew what they were doing could build it for 12 to 15, tops. The cost discrepancy implied either catastrophically incompetent project management or something considerably darker, like a contractor with a relationship to someone on the HOA board, billing at a comfortable premium. That question, where did the money go, became a thread. And threads, when you pull them slowly and carefully, have a way of unraveling entire sweaters. Deirdre, meanwhile, was posting photos of the Whitmore Pines Community Annex on the neighborhood Facebook group with the caption, "Almost ready. So proud of what our community is building together." $47,000, someone else's land, an illegal permit application, a grand opening in 6 weeks. Sure, Deirdre, let's see what you've built. The thread Rupert and I started pulling led somewhere none of us had expected. I want to be precise here, because precision is what made this matter. Prescott had been doing background research on the Whitmore Pines HOA's governing documents, the CC&Rs, the bylaws, the original plat filings from when the subdivision was developed in 2004. Standard due diligence. He'd reviewed most of it quickly, flagged the relevant boundary language, moved on. But one evening, he called me with a slightly different energy in his voice. "Garth," he said, "did you know your grandfather had a recorded easement with the original Whitmore Pines developer?" I did not know that. In 2003, when the subdivision was being planned and platted, the original developer, a company called Meridian Land Partners, had negotiated an easement with my father for utility routing. A sewer main ran underground along the eastern edge of my pasture to service the subdivision. My father had granted the easement in exchange for a one-time payment, and notably, a specific protective clause. The clause was on page 4 of the easement agreement, recorded in the county land records, and it had been sitting there for 18 years without anyone apparently reading it. The clause read, in relevant part, "Grantor retains the right to require removal at grantee's expense of any structure, temporary or permanent, placed within the easement corridor or on grantor's adjacent parcel without express written consent. Failure to remove within 30 days of written notice shall subject grantee and all successors in interest to liquidated damages of $500 per day. Successors in interest." The Whitmore Pines HOA was, legally, a successor in interest to Meridian Land Partners. They had inherited the utility easement. They had also, unknowingly, inherited this clause. Prescott explained it to me in his unhurried way, while I sat in the shop with the overhead light humming. The easement corridor runs approximately 20 feet into your pasture from the property line. Based on HOA's survey, the corner of that building sits inside that corridor, which means the HOA didn't just trespass on your land. They violated a recorded easement agreement that gives you the right to force removal and charge $500 a day until they do. The building had been standing for 31 days by the time Prescott found this clause. That was $15,500 in accrued liquidated damages, and the meter was running. We also discovered something about Deirdre specifically. She had been the person who reviewed the HOA's governing documents when she took office. She had signed a certification stating she had read and understood all recorded agreements associated with the property, including, presumably, the easement. Either she hadn't read it, which was negligence, or she had read it and proceeded anyway, which was something considerably worse. I sat with this information for about 20 minutes. There was a great horned owl calling somewhere out past the north fence. The October cold had gotten into the shop, and the smell of old motor oil and sawdust was thick and familiar. I thought about my father shaking hands with the Meridian guy on this same land. I thought about him writing that note on the kitchen table. "Don't let anybody push you around, son." He'd given me a legal weapon in 2003, and I hadn't even known I was holding it. I almost laughed. Almost. I was too busy calling Prescott back to start composing the notice. The next 3 weeks were the most satisfying work I've done since I rebuilt the gearbox on my grandfather's tractor in 2014. Prescott and I mapped out every piece of what we had and laid it in sequence. The unauthorized structure, the fraudulent boundary description on the variance application, the procedural failure to notify me of the hearing, the easement clause, the financial discrepancy on the $47,000 expenditure. Each piece was a separate avenue of action, and we were going to use all of them, just not all at once, and not in any order that telegraphed what we were doing. The first move was a formal objection to the variance hearing, filed with the County Planning Board. Prescott submitted our survey, HOA's certified boundary report, and a 14-page brief laying out why the boundary description in the variance application was materially incorrect. We attached a copy of the original 1987 deed and both surveys. We requested that the Planning Board deny the variance and refer the application to the county's Code Compliance Division for investigation of the boundary discrepancy. That request, the referral to Code Compliance, was the key, because Code Compliance has subpoena authority. They can demand contractor records, HOA meeting minutes, financial documents. They can do in 3 weeks what would take us months of civil discovery. The second move was the easement notice. Prescott drafted a formal written demand under the 2003 easement clause, served it on the HOA board and their attorney Winspear. The notice stated that the structure violated the easement corridor, that the 30-day removal clock was now officially running, and that accrued liquidated damages as of the date of service were $18,000. The daily rate would continue at $500. Thaddeus Winspear's response this time was notably less chipper. Meanwhile, I reached out to Rupert Calloway and 2 other Whitmore Pines homeowners who'd been quietly frustrated with Deirdre's board for years. A woman named Claudette Paris, who'd been trying to get the pool resurfaced for 2 years and kept getting told funds were allocated elsewhere, and a retired electrician named Boyd Hennessy, who'd sent 3 formal complaints about the board's meeting minutes transparency and received form letter brush-offs in return. We weren't organizing a mob, we were building a record. Rupert filed a formal records demand for all HOA financial documents related to the Community Infrastructure Improvement expenditure. Claudette filed a separate records demand for board meeting minutes from the previous 18 months. Boyd, who had a meticulous paper trail of his own unanswered complaints, met with Prescott and signed a declaration about the transparency issues. Under Maryland HOA law, repeated failure to respond to records requests is itself an actionable violation, and the HOA board had been stonewalling for months. Here's the thing about HOA boards that overreach. They rely on the assumption that the people they're abusing either don't know the rules or can't afford to fight them. Maryland's Homeowners Association Act is actually pretty robust in terms of member rights. Section 11B-112 of the Maryland Code gives members the right to inspect and copy financial records. Violations can result in court-ordered disclosure and attorney fee awards. The board had been casually ignoring this for years. Now it was in writing, documented by 3 separate homeowners, with a lawyer's name on the correspondence. The financial investigation started yielding results around the 2nd week of November. The contractor who'd built the annex was a company called Ridgetop Construction, LLC. The license was registered to a man named Vic Salerno. What was interesting about Vic Salerno was that his wife's maiden name was Colton, Deirdre Colton, her brother-in-law. The board had awarded a $47,000 contract to the president's brother-in-law without a competitive bid process, without a disclosed conflict of interest, and, based on the actual construction cost, with an apparent markup of somewhere between $20,000 and $30,000. That's not illegal in the way that bank robbery is illegal, but it is a breach of fiduciary duty. In a civil suit, it's called self-dealing, and HOA board members can be held personally liable for it. The trap had been set, not with ropes or pitfalls, but with paper. Documents, filings, records requests, legal notices, all converging in a sequence that Deirdre had no idea was in motion. She was still posting Facebook updates about the grand opening. December 15th. She'd invited the county commissioner, apparently, had a caterer, a ribbon. I marked December 15th on my shop calendar and drew a circle around it. Deirdre was not unintelligent. I want to be clear about that, because underestimating her at this point would have been a mistake I couldn't afford. When the easement demand letter arrived and the planning board objection was filed, she understood, correctly, that the situation had shifted from nuisance to threat. What she did next tells you a lot about how people like her respond to genuine accountability. They don't retreat, they attack sideways. The first move came on a Tuesday in mid-November, a call from a reporter at the Calvert Recorder, a small county weekly, asking if I wanted to comment on allegations from local residents that you have been harassing the Whitmore Pines community with frivolous legal threats. I asked the reporter, a young woman named Faye, clearly reading off a prepared list of questions, who had contacted her. She said she wasn't at liberty to say, but the call had come from someone with knowledge of the HOA's good faith development efforts. I told Faye I'd be happy to share the full documented record of the situation, and invited her to review the county land records and the planning board filing herself. I gave her Prescott's number. She called back 2 days later with a noticeably different energy. "Mr. Maddox," she said carefully, "I think I may have been given a misleading picture of this situation." Deirdre had tried to run a press smear and accidentally sent a reporter digging into the actual facts. The second move was a certified letter from Winspear, claiming that my refusal to negotiate in good faith regarding a potential boundary adjustment agreement was potentially actionable under Maryland's frivolous litigation statutes. This was, to use Prescott's exact language, complete nonsense. A property owner defending their documented boundary against an illegal encroachment cannot be accused of frivolous litigation. Winspear had to know this. The letter was theater, designed to make me feel like I was taking a legal risk by continuing to push. Prescott responded with a one-page letter that was politely devastating. He noted that the Maryland frivolous litigation statute applies to plaintiffs filing baseless claims, not to property owners responding to encroachments. He further noted that if Winspear continued to file letters containing material misrepresentations of law, He would consider whether they constituted an ethical complaint matter before the Maryland State Bar. We did not hear back from Winspear for 11 days. The third and most personally irritating move was what happened with my workshop permit. I'd pulled a building permit in 2019 to add an addition to my concrete shop pad. The permit had been closed out and signed off, but in mid-November, I received a notice from the county building department stating that a complaint had been received, alleging the addition didn't comply with the original permit drawings, and requesting a re-inspection. The complaint had been filed anonymously. I had a strong guess about who filed it. I called my original contractor, who still had his files, pulled out the permit drawings, and called the building inspector's office to schedule the re-inspection. The inspector came out on a gray Wednesday morning, boots crunching on the frozen gravel, and spent about 25 minutes going over everything. He looked at the drawings, he looked at the construction, he walked around the perimeter, he wrote something on his clipboard. "Whoever filed this complaint," he said, putting his pen away, "hasn't read a building code recently. Everything's fine. I'm going to note in the record that this was an unfounded complaint." He paused. "You having a property dispute with someone?" "Working through it," I said. He nodded like a man who'd seen this before. "Those complaints sometimes come in clusters when people are fighting over land. Don't worry about it." He was right to say don't worry, but I did note it carefully. Deirdre had now tried a press smear, a legal intimidation letter, and a fake building complaint in the span of 3 weeks. Each attempt was somewhat sophisticated, but had the same underlying flaw. It was reactive, emotional, and untethered from the actual facts. When you're operating from a position of documented wrongdoing, and you start throwing haymakers hoping one of them lands, you're not strategizing anymore. You're panicking. And panicking people make mistakes. Rupert called me the night before the planning board hearing to let me know that the HOA had sent a letter to every Whitmore Pines homeowner, claiming the variance hearing was a routine administrative procedure, and that the land situation was fully resolved. I had 17 documents that said otherwise. The hearing was in 4 days, December 11th, 4 days before the grand opening. The planning board hearing room in Prince Frederick smells like old carpet and municipal coffee, the flat, slightly burnt kind that sits on a hot plate for hours and develops a particular character that you never forget. I got there early on the morning of December 11th, 20 minutes before the session opened. Rupert Calloway came with me. So did Claudette Paris and Boyd Hennessy. We had a thick 3-ring binder each, tabbed and indexed, because Prescott had prepared presentation copies of every supporting document. Deirdre arrived with Winspear, a contractor she appeared to have brought for moral support, and 2 HOA board members I recognized from neighborhood event photos. She was wearing a burgundy blazer and carrying a presentation folder that looked like it had been assembled at a Kinko's that morning. She saw our binders and her expression flickered, just for a moment, before resettling into the composed, "we're confident this will go fine" face. The planning board had 5 members. The chair was a retired civil engineer named Herschel Mabry, who had the energy of a man who'd been through a lot of boundary disputes and had stopped being surprised by any of them. Prescott presented first. He laid out the boundary discrepancy methodically, with the survey maps projected on the room's wall-mounted screen. He showed the 1987 deed, the 2 surveys, and Hoke's current certification, all consistent, all showing the same line. He then showed the variance application's stated boundary, 18 feet off. He explained the easement clause and its implications for the structure. He noted the procedural failure to notify the adjacent landowner. He did this in about 22 minutes, in plain language, without a single sarcastic aside. The board chair took notes throughout. Winspear's presentation was considerably shakier. His core argument was that the boundary discrepancy was a genuine surveying ambiguity that the HOA had reasonably relied on. But when the board chair asked him to produce a survey supporting the HOA's claimed boundary, Winspear did not have one. He had the variance application, which cited a boundary. He did not have an independent certified survey confirming that boundary. The board chair asked this question twice, in different words, and got the same non-answer twice. At one point, Deirdre leaned over and whispered something to Winspear, and he held up a hand to pause the chair. There was a quiet conference. Then Winspear said they would like to request a 60-day continuance to obtain their own survey. The board chair looked at him steadily. "Counselor, this structure has been on the ground for 6 weeks. You're requesting 60 more days before providing evidence to support the boundary claim it was built on. Winspear said yes. The board denied the continuance. They deliberated for 17 minutes. They returned a unanimous denial of the variance application. The chair also formally referred the falsified boundary description to the county's Code Compliance Division for investigation of the permit application. He did it in one sentence, in a flat voice, without elaboration, which somehow made it more final. Deirdre's face in that moment was something I'll carry for a while. Not the anger. I expected the anger. It was the disbelief. She had genuinely not believed this would happen. She'd moved through the world for so long with petty authority working in her favor that the idea of clean, documented, boring, methodical evidence defeating her simply hadn't registered as possible. She walked out of the hearing room ahead of Winspear and didn't look at me. Here's what the planning board denial meant practically. The variance was dead. The building had no legal permit basis. The code compliance referral meant inspectors would come, and they would note the boundary violation in an official county record. Once it was in that record, the building was a documented illegal structure on another person's property. Under Maryland law, the county then has its own authority to issue a demolition order for structures that remain in zoning violation after notice. The county didn't need me to force demolition. The county could do it themselves and bill the responsible party for the cost. I let Prescott handle the paperwork and went home. The white oak saplings along the north fence had dropped their leaves by then, their branches bare and gray against the December sky, and the frozen grass crunched under my boots. I stood looking at the Whitmore Pines Annex for a minute, the fresh metal roof, the little sign, the clean lumber still visible in the framing gaps. $47,000. 5 days until their grand opening. The city's code compliance inspector was scheduled to come December 13th. December 13th arrived with a hard frost that turned every blade of grass on the pasture silver and made the gravel crunch like broken glass underfoot. The code compliance inspector, a deliberate, unsmiling man named Calvin Pruitt, who had been with the county for 19 years, arrived at 8:47 a.m. in a white county truck. He had a clipboard, a laser measure, and the planning board referral in hand. I watched from the shop door with my coffee, while Calvin walked the perimeter of the Whitmore Pines Annex. No rush, no drama, just a man doing his job with the quiet certainty of someone who has measured a lot of things and found a lot of people wrong. He paced the distance from Hoke's boundary stakes to the nearest wall, measured again, photographed the building from 6 angles, cross-referenced the county GIS map on his tablet. 31 minutes total. Then he walked over to where I was standing, tucked his pen behind his ear, and said simply, "It's on your land." I said I knew that. He said he'd be issuing a notice of violation and a demolition order to the structure's permit applicant, the Whitmore Pines HOA, with a 7-day voluntary removal window. If they failed to remove it within 7 days, the county would contract the removal and invoice the HOA directly. Unpaid invoices would result in a lien against HOA property. 7 days. The grand opening was in 2 days. Calvin got back in his white truck and drove away without ceremony. I watched the truck disappear down Sycamore Ridge Road and felt something I hadn't felt in months, the particular quiet of a plan working exactly the way it was supposed to. I called Rupert. I called Claudette. I told them what was coming and suggested they make sure they were present on December 15th with their eyes open and their phones charged. The grand opening arrived cold and bright. Deirdre had done the whole thing properly. String lights laced along the annex frame, a folding table loaded with Christmas cookies and hot apple cider, a small Bluetooth speaker playing holiday music into the frozen air. The county commissioner's aide showed up, which was one step below the endorsement Deirdre had been chasing, but close enough for her to claim it. A cluster of Whitmore Pines residents stood around in their winter coats, some genuinely curious, some visibly uncomfortable with rumors they'd been hearing through the neighborhood grapevine for weeks. I was not there. I didn't need to be. I had people there. What happened, and Rupert watched every second of it, as did Claudette, and the Calvert Recorder's reporter Faye, who had done her own 2 weeks of digging and showed up with a notepad and a camera, was this. Deirdre had just finished her ribbon-cutting remarks. She was smiling. She was in her element. She had built something she believed, and she was being celebrated for it. Then a county truck pulled up on the service road adjacent to the pasture. Calvin Pruitt stepped out, walked to the front of the building with the unhurried pace of a man who has delivered bad news to overconfident people before, and stapled a laminated notice of violation to the doorframe. 2 clean staples, yellow paper, hard to miss from 20 feet. Faye's camera clicked. Deirdre came over. She read the notice. She read it again. She looked at Calvin with an expression cycling rapidly between confusion, indignation, and something that might have been the first cold touch of genuine fear. "This is not happening today," she said, loud enough that the cookie table crowd went quiet. Calvin looked at her with the expression of a man who has been doing this job for 19 years and has heard every variation of that sentence. "Ma'am, the notice has been served. 7 days for voluntary removal. After that, county contractors perform the removal and costs are assessed to the permit applicant." He got back in his truck. He drove away. Deirdre stood in front of her string-lit annex, in front of the cookies and cider and the commissioner's aide and 24 of her neighbors, holding a violation notice stapled to the building she had constructed illegally on someone else's land, funded with HOA money contracted to her own brother-in-law. The silence that followed lasted a long time. Rupert told me it was the most interesting silence he'd ever stood inside. The night before the county's 7-day window expired, my phone rang. Calvin Pruitt's office, an administrative assistant, polite and neutral, asking a standard procedural question. Did I want to request any additional time before the county proceeded with contracted removal? I thought about it for exactly 1 second. "No," I said. "Proceed." She noted it in the record. We hung up. I set the phone down on the workbench, poured a last cup of coffee, and went to bed early for the first time in months. December 22nd, 1 day before the window closed. The demolition crew arrived at first light. A skid steer, a flatbed trailer, 2 guys in hard hats who clearly had no opinion about HOA politics, and simply needed to be somewhere else by noon. I stood in the shop doorway with my coffee, boots laced this time, watching. The metal roof came off in sheets, catching the winter light as it went. The framing came down in under 40 minutes. Clean, efficient, no ceremony. The concrete footing would take another pass to break up and haul, but by the time I finished that second cup, the structure that had cost $47,000 of other people's money to build illegally on my land was a pile of materials on a flatbed. The air smelled like diesel exhaust and cold turned earth. The pasture was mine again. Faye's article ran 3 days later. It was thorough, restrained, and deeply unflattering to everyone who deserved it. By publication date, the Code Compliance Division had already opened a secondary investigation into the fraudulent boundary description on the permit application, a referral that would eventually reach the county attorney's office. Deirdre did not attend the next HOA board meeting. She didn't attend the one after that either. The months after the demolition were quieter than I expected, not without consequence. There was still a great deal to resolve, but quiet in the way that things get quiet after a storm, when the pressure finally drops. The civil suit Prescott filed in January settled in March. The HOA, by then operating under emergency board oversight, after 3 members resigned following Faye's article, agreed to pay $41,000 in damages, the accrued liquidated damages under the easement clause, the cost of hoax surveys, Prescott's legal fees, and a further sum for the diminished use of my pasture during the period the structure stood. They did not admit wrongdoing in the settlement, which is standard language that everyone involved understood for what it was. Deirdre resigned from the HOA board in January. Winspear quietly withdrew from the matter. The county attorney's office reviewed the permit application and ultimately determined that the falsified boundary description constituted a fraudulent filing. The matter was referred to the state's attorney with a recommendation for further review. As of the time of this telling, that process is ongoing. I'll let you draw your own conclusions about how seriously county attorneys take fraudulent permit applications. The $47,000 expenditure discrepancy and the contractor relationship were reviewed by the new HOA board, assisted by a forensic accountant hired specifically for the purpose. The results of that review became the basis for a separate civil action by the HOA against Deirdre personally. That's an HOA suing its former president. Sometimes justice has a sense of humor. Rupert Calloway became the new HOA board president in April. His first act was to create a publicly accessible digital financial portal for all Whitmore Pines homeowners. His second was to finally approve the pool resurfacing Claudette had been requesting for 2 years. The pool reopened in June. I was not invited to the party. I was not technically a community member, but Claudette brought a plate of her lemon bars to my door anyway, and we stood on the porch in the spring sun and talked for about an hour. The settlement money, after Prescott's fees, left me with roughly $26,000. I thought about what to do with it for a while. In the end, I did 2 things. I donated $12,000 to the Calvert County 4-H Foundation, which funds agricultural education programs for kids in the county. My father had gone through 4-H. I figured the money had a kind of rightness going back there. The remaining $14,000 I used to install a proper split-rail fence along the eastern edge of my property, with survey marker posts embedded in concrete at every corner and the boundary coordinates engraved on a small aluminum plate at each marker. If someone ever tries to dispute that line again, they will have to explain away a pretty emphatic fence. The white oak saplings along the north edge are doing well. They've put on a good foot of growth since I planted them, and in 30 years they'll be the kind of trees that make people stop and look. I think Walt Maddox would have liked that. Here is what I want you to take away from this, because this wasn't just my story. This is a template. When someone misuses authority over property you own, the answer is documentation, patience, and the right professionals. A certified survey is approximately $800 to $1,500. A real estate attorney's initial consultation is often free. County land records are public and usually searchable online. The easement clauses in your deed may contain protections you've never read. Homeowner association member rights under your state's HOA Act are almost always more robust than the board wants you to believe. The 3 most important things I did: got a fresh survey immediately, found the easement clause before they knew I had it, and never once confronted Deirdre directly until the documents were ready. Every instinct says go argue, go yell, go stand in front of that building and make a scene. Resist that instinct. The quiet, patient version of you is the one who wins. I still have Walt's note from the kitchen table. It's in my wallet now, folded small and worn at the creases. Don't let anybody push you around, son. Good advice. Turns out it holds up.
You know what got me about this whole thing? Not the bulldozer, not a $41,000 settlement, not even Deirdre standing there in front of her string lights holding a yellow violation notice like the rule had never once occurred to her. It was 2 words: no, proceed. That's all Gad says when the county called the night before demolition. No speech, no victory lap, just no, proceed, hang up, go to bed. Because he wasn't fighting her, he was documenting her. Every survey stake, every certified letter, every line in that 2003 easement agreement she never bothered to read. $500 a day, by the way, from the moment that frame went up, wasn't built out of spite. It was built out of patience, and patience in a property dispute is the most dangerous thing in the room. Here's what Deirdre miscalculated. She looked at 6 acres and a quiet man and thought he wouldn't push back. That specific assumption, that's where she lost everything. Drop it in the comments. Has anyone ever assumed you wouldn't fight back? An HOA, a landlord, a contractor who figured you didn't know enough. Because most of the time, they are counting on exactly that. If this one hit home, share it with someone who needs to hear it. Subscribe if you haven't. Next story makes this one look like a neighborly disagreement. The most dangerous person in a property dispute isn't the loudest one in the room. It's the one taking notes.